This week is Senator Mike Lee, Republican of Utah, a member of the Senate Judiciary Committee. And joining us with the questioning is Neil Zesnewski, who covers Congress for CQ Roll Call, and legal affairs reporter for the Wall Street Journal, Brent Kendal. Thank you both for being with us. Senator, Monday being the first Monday in October, the start of a new term for the U.S. Supreme Court and the first full term for Justice Neil Gorsuch, who you supported in the confirmation hearings. A particular issue or cases that you're following in the term ahead?
There are a few interesting cases that will be argued in the forthcoming term. One of them was just recently granted. The Janus case involves this issue that was before the Supreme Court, before Justice Scalia's death. And it deals with the ability to collect union dues from state employees without their willingness to do so, against their will. It should be an interesting issue, an issue that was left open, being deadlocked 4-4 the year that Justice Scalia died. There's also the Masterpiece Cake Shop that involves a bakery owner who was charged by the Colorado Civil Rights Commission for refusing to decorate a specialty cake for a same-sex couple in connection with their wedding. Both of those should be interesting, as well as Gill v. Whitford, a Wisconsin case dealing with redistricting.
You clerked for Justice Alito. What role do you think his successor, Neil Gorsuch, will have on the court and his interactions with his fellow justices?
Well, I think Justice Gorsuch is going to have a profound impact on the court, and I think he will be someone who falls very much in the legacy of his predecessor. He will be a coalition builder by virtue of the fact that he's very smart. He's also not afraid to express his opinions. And he's very much in the mold of Justice Scalia, in the sense that his focus is on the text of the statute being construed or the constitutional provision at issue.
Let me turn to Brent Kendal of the Wall Street Journal.
Senator, you raised the Masterpiece case. I saw that recently you filed a friend of the court brief in that case supporting the Colorado baker. I wonder if you could just sort of walk us through your thought process and how you think, judges should be balancing, public accommodations law versus the religious rights of citizens. And what would you say to people who say, that this case, if the baker won, at least threatened to drive sort of a hole through, accommodations laws that have, prevented businesses from sort of picking and choosing who they served?
Yes, I'm happy to answer that question. This case really is not about public accommodations laws so much as it is about compelled speech. I view this as a compelled speech case. The bakery owner here was being asked to do something expressive, to engage in expressive conduct. The cake baker in this circumstance was not unwilling in any respect to do business with same-sex couples. What he didn't want to do was to use his expressive talents to make a specialty cake in this circumstance. He would have been happy to sell one off the shelf, wasn't inclined to participate in the wedding by putting his expressive talents to work in a unique way in this case. So in that respect, I think this case is more properly viewed as something involving compelled speech. There are, as you know, heightened standards that apply when the government is trying to compel someone to engage in speech or to express themselves against their own will.
Among the other cases you mentioned is the Gill v. Whitford case on partisan gerrymandering. The court has had these cases before and has never quite been able to resolve them, and is trying to consider once again whether there are any constitutional limits, and if there are limits on how much partisanship and redistricting is too much, how to draw those. What are your thoughts on this case? I know at least some of your colleagues have filed briefs on this.
It'll certainly be interesting. This is one area where the court has struggled to find a judicially manageable standard. People will frequently look at redistricting and at the boundaries drawn by a state legislature after a census and say, well, that makes no sense. It's clearly wrong. But the fact that something makes no sense and looks clearly wrong, feels wrong, smells wrong, it doesn't always mean that there's a judicially manageable standard according to which the court can consistently apply constitutional limits.
Another case that was on the docket, which looked to be sort of the marquee case, and at least for now is not, is the case over President Trump's travel ban. As we know, the White House recently changed its travel restriction rules, and the court is now considering what it should do with this case. I mean, do you have thoughts on whether the court would be best off punting here, and what do you make of the litigation as it's unfolded so far?
Well, I think that particular case is moot. And now the court has suspended this case from its argument calendar. They can still bring it back. They haven't dismissed the cert petition as improvidently granted or anything like that. They've just suspended it from the argument calendar while they wait for briefing specifically on the question of mootness. I have little doubt but that the court will conclude that this case is moot, so I don't think it's going back on the calendar.
We talked about Justice Gorsuch. Obviously, this is his first full term, and he's had some pretty striking impacts in the little time he's been on the court so far. I wonder, what you're watching for from him this term, and I also wanted to ask, in at least a few instances now, we've seen early on him line up in a camp with Justice Alito, who you used to clerk for, and Justice Thomas, and the Chief Justice and Justice Kennedy, on the other hand, staking out sort of a more middle ground position on a couple things. This happened in the travel ban litigation, where the Chief Justice and Kennedy joined with the liberals, sort of create this middle ground approach, and the other three conservatives would have allowed the president to enforce all of his ban. And it happened even this week in a death penalty case where a group of justices stayed an execution in Georgia, but Justice Gorsuch, Justice Alito, and Justice Thomas would not have done so. I wonder what you make of this sort of different approach between the two conservative camps.
Yeah, look, I think you will continue to see similar patterns like that. I think he views the law in much the same way as Justice Thomas and as my former boss, Justice Alito, in much the same way that his predecessor saw the world in the same light. I also think that, we have to remember that most cases in the Supreme Court are not decided 5-4. Most of them are not even decided 6-3. A whole lot of them are decided unanimously, or 8-1, or 7-2. It's in the close cases and the politically charged cases where you tend to see much more of a division. But I do suspect that you'll often see 4 justices lining up quite consistently on the conservative side of things, often with the support of Justice Kennedy, but not always. I also think you'll continue to see real meaning, value being added by Justice Gorsuch. In other words, I don't think he'll be blindly following his conservative colleagues in those cases. I think he will be contributing in a very meaningful way to their analytical skills. He is very much in the same league with them in terms of his confidence, in terms of his judicial philosophy, in his ability to apply the law to the facts of any case.
Senator Lee, did Senator Mitch McConnell